Mhm. Hello, hi everyone. Just waiting for team Kamod Anashim Shitztarfu. More people will join, and we'll start in a couple of minutes. Okay, as Shalom Lekulam, Bak Latfil, I'm Yonatan Natan, Shutaf B'Meitar, Jonathan Nathan, a partner of Meitar in the Capital Markets Group. אני אעביר את הוובינר הזה באנגלית, אני חושב שזה יותר טוב, מניסיוני, יותר ישראלים יודעים אנגלית יותר טוב ממה שאמריקאים יודעים עברית. אז, okay, so if people have any questions, they should please, over the course of this webinar, which will be about approximately an hour, they can submit like through the Q&A function, and I'll be able to see. I won't be able to hear you, but I will be able to see your questions in the Q&A, and I'll attempt to address those questions at the end of the presentation. So basically, I assume that people participating today are either internal counsel or just insiders of public companies or directors, anybody who's interested in a 10b5-1 plan, or anybody else who's just interested in the topic. I appreciate your joining me. Just by way of background, basically Rule 10b5-1 has been around for over 20 years. It's under the Exchange Act, going back to it relates to Section 10b5, which most of you have probably heard in Rule 10b5, Section 10b of the Exchange Act. As you can hopefully see try and go along with the slides. As you know, there's a prohibition under the Exchange Act of purchasing or selling or entering into any transaction while in possession of material non-public information. Obviously, there's a concern that insiders, whether directors, officers, or anyone else who might be exposed to inside information, would, use that, possesses that information and potentially would use that information to in enacting securities transactions that undermines the integrity of the markets. That's something that the SEC has always emphasized. We want fair play, basically. So that's the prohibition. Rule 10b5-1 is meant to do a number of things. Specifically, it's meant to enable insiders to allow them to enter into transactions without the concern that they're utilizing material non-public information. It provides them with liquidity. It provides them with to be able to, it provides the issuer with a certain level of certainty that insiders are not overstepping their bounds and using material inside information in enacting securities transactions. And also it, basically the idea behind it is that it provides an affirmative defense. Now, affirmative defense is never a guarantee that somebody's not going to sue you or the SEC is not going to bring an action against you, but it is it does provide you a defense should that action arise, should somebody sue you or anything like that. Now, originally, the 10b5-1 plan, affirmative defense, has been running for a long period of time, 20 years or so. Basically, just going over the original version of it. It required certain conditions, right? It required that you it requires that you that you enter into it prior to possessing the non-public information. So you need to do it during an insider trading window. That's when you need to adopt the plan, right? However, after that point, there were various, I guess things that the current chair of the SEC, Gary Gensler, he pointed out there were various abuses going on. It's important to understand the current administration at the SEC takes a very skeptical view of insiders, and it almost assumes that even if it's a 10b5-1 plan is adopted during an insider trading window, that the insider most likely has some sort of inside information. So the best way to cure that is to provide for some sort of cleansing period or a waiting period, a cooling off period. So that's a central feature of the current reforms, I would say, of the as a Rule 10b5-1 currently. So that's something that the current SEC staff had put a great emphasis on, and then in December of 2022 they adopted these amendments to Rule 10b5-1, which went into effect February 27, 2023. I just want to take note that while most of these things are already in effect, there's certain issuer-related disclosures that we'll get to, which don't necessarily apply currently. They won't even apply to the 10K or the 20F that your companies file at the end of this year and start of 2024. They actually won't even apply to the following years, the 20F or 10K for 2024, which will be filed in 2025. That's because the effective period starts with fiscal periods that begin after April 2023. So that means 2023 is out. Only 2024 will be the first annual period that need to be subject to the new rules as far as issuer disclosures. Okay, so basically we just discussed some of the advantages of 10b5-1 plans. It provides greater certainty to insiders, more opportunities for liquidity. Obviously, most companies have an insider trading blackout period. So you need to, in order to get around that, you need a 10b5-1 plan that can run on automatic pilot. Also, there's less negative publicity because it's assumed that you're not taking advantage of the market. So shareholders, investors are not concerned that the insider is gaming the market. So that's one of the advantages. Also, it makes it easier for counsel, for some of you who are presumably on this webinar, who are insider legal counsel to various public companies. It's if you know that your insiders have a plan in place that could just continue to run automatically. You don't have to worry about clearing for them various trades along the way. Okay, so the existing rules, the existing rule before the amendments had certain conditions. Just to state them again clearly, there's a good faith requirement, which basically is that's a sort of like an overriding theme throughout the securities laws, that everything needs to be done in good faith. You're not trying to get around some securities law violation. It needs to be adopted at a time of when you're not aware of any material non-public information, basically during a insider trading window after the earnings release, basically after a day or two, depending on the insider trading policy, but a day or two after the insider trading period window opens. So that's the time when a 10b5-1 plan can be adopted. The terms of the plan have to specify various factors, whether it's amount, price, date of transactions, some sort of formula, algorithm. You could say the share price goes above $20. I want you to sell, 1,000 shares a month. When the share price goes back down below $10, I want, I want you to stop selling. So you can have various conditions as long as it's all spelled out in advance. That's the key. And you can't influence, it needs to be on automatic pilot. You can't subsequently influence anything. Also another condition is you can't have a hedging position or an opposite transaction. That's that was before the amendments even to the rule. You can't have, a 10b5-1 plan going for various, sales, and then you establish a long position where you're basically doing exactly the opposite to hedge against it. That you would not be entitled to the defense of Rule 10b5-1 of the affirmative defense if you established a hedging position that went completely against the original plan. So those are current conditions about even before the amendment. So the idea is the autopilot concept. Just to share something with you that's a little funny, I think, relates to autopilot. Just a clip from one of my childhood favorite films. When you think of an autopilot,
at this point, the entire digestive system collapses, accompanied by uncontrollable flatulence, until finally, of course, it's reduced to a quivering, wasted piece of jelly. I'll go back to the passages.
Okay, so that was the autopilot bit from Airplane. Those of you are remember that movie from 1980. Any case, the idea behind it is that, like I said before, the current SEC chair Gensler has a skeptical view. He sort of takes the approach that most insiders are deemed to have inside information, even if they're adopting a 10b5-1 plan during an insider trading window when they're supposed to not have any inside information. So by inserting like a cooling off period prior to the effectiveness of any 10b5-1 plan, that's the key new feature of these amendments to Rule 10b5-1. And there, by the passage of time, basically, is what cleanses the insider from having the deemed inside information when he adopted the 10b5-1 plan. So just to give an overview of what the amendments involve, we have the cooling off period I mentioned. There's different cooling. We'll see there's different cooling off periods for directors and officers versus other employees. Directors and officers have at least a 90-day period or until the next after the next quarterly earnings release or annual earnings release. The cooling off period does not need to exceed 120 days for directors and officers. That's the maximum. For all other employees, it's just a 30-day required cooling off period before the effectiveness of a plan, that a 10b5-1 plan that you adopt. So that's a new feature. There's a requirement now under 10b5-1 that you need to provide in the body of the agreement itself, which is typically entered into with a broker, that you need to have a representation that you do not currently possess material non-public information, or you're not just using this as a way of getting around the securities law. So you need to have some sort of representation in the plan itself. or else you're not eligible for the affirmative defense. Basically, your 10b5-1 plan is not worth anything if you don't have that certification or representation in the agreement with the broker that you have the 10b5-1 plan with. There's a restriction on multiple overlapping plans or arrangements. Basically, the idea behind this is to get at the point that you can't game the system. You can't have, various plans doing different things, and ultimately you're getting around. It's similar to the hedging idea that you have to have, it has to be clear what you're doing. It needs to be transparent. It needs to be all within one plan. You can't have various plans going on at the same time, which basically are a way of getting around the, you could be gaming the system. That's the SEC's concern. So you need to have it needs to be one plan. And there's also a point about single trade arrangements we'll get into. If it's a 10b5-1 plan, sometimes all the transactions are done in one transaction. So there's limitations on that. You can't do more than one of those in every 12-month period. I was thinking most 10b5-1 plans are not like that. Most of them run over the course of time, but it's just something to keep in mind. There's a new requirement about good faith. Until now, the SEC basically, the 10b5-1 had the requirement that a 10b5-1 plan needs to be established in good faith. Now it needs to you need to act upon the 10b5-1 plan in good faith. That's getting at the fact that you can't do things that subsequently, while the 10b5-1 plan is up and running, you can't try and influence. For example, you can't influence the issuer to time this earnings release at a certain point, because under my 10b5-1 plan, I'm about to do a sale. And I know there's bad news coming up and the price is about to go down. So I can't influence the issuer to push off the announcement of the bad news so that I can get my sale in at the higher price before the price goes down in the market. So that's part of the requirement, that you need to act upon your 10b5-1 plan in good faith. That's a new requirement. Again, SEC is getting at people gaming the system. Beyond everything that we're talking about for insiders, for those of you who are inside counsel to issuers, there are various issuer disclosures that have been added by the new 10b5-1 amendments. Many of them apply just to U.S. domestic issuers. Most Israeli clients of ours are not necessarily, they're foreign private issuers. But for foreign private issuers, there's only one of these requirements applies. We'll get into that, but there is an annual requirement regarding policies and procedures, and that will apply to foreign private issuers in Form 20F as new item 16J, and you'll be required to file copies of the insider trading policy for the first time as an exhibit to the Form 10K or the Form 20F. So we'll see that. And also there are various other things that also other amendments to the rule that only apply to U.S. domestic companies. Again, from the issuer side. First of all, in the proxy statement, there's going to be a new table related to executive compensation, disclosure regarding the timing of your option grants. Often, the SEC is getting at the fact that you don't want equity being granted prior to the release of material non-public information, because it doesn't make sense. Then the insiders are getting the benefit of a change in the stock price that's going to happen afterwards. The best thing is to have, obviously, is when you have equity grants after releasing all public information, so that the equity grant is granted at a valuation for the company that matches what the market feels it should. So it's important to do the equity grants after the announcement of public information, and therefore the SEC is adding some executive compensation disclosure regarding if equity grants are done prior to the release of non-public information. So we're going to see that, but that also only applies to U.S. issuers, does not apply to foreign private issuers. Okay, so just jumping right in, we said before, the most important thing I think that Chair Gensler was getting at was the cooling off periods. If you're a director or officer, you have to wait the longer of either 90 days or 2 business days following the disclosure of your next quarterly or annual financial result. And before you're the 10b5-1 plan that you're adopting, anyway, you're adopting it during an insider trading period window under your insider trading policy. But when you have no material non-public information, but still it cannot go effective for at least 90 days, up to a maximum of 120 days. Again, the concern is that the SEC is skeptical of that you might have some sort of plan and you might know material non-public information, so they want you to wait as far as the effectiveness of it. However, for other employees, that only applies, directors and officers. Officers has a definition given under Section 16 of the Exchange Act. Basically, it's a policy-making function. We know under Israeli law, there's a concept of a nosei misra, or office holder. It's a broader category. Here, it needs to be a policy-making function. Basically, for most of our clients, that's like a Form 20F listed officer. They have a policy-making function at the parent company level. For those officers, those are the ones who are subject to the 90 to the 120 day, basically till the next earnings release period of cooling off before your 10b5-1 plan can go into effect. If you're a lower level officer, then you generally would not be subject to that. You would basically follow the same rule as any other employee. You'd have a 30-day cooling off period. Which is generally, until now, that in most cases, the form of 10b5-1 plan that you enter into with your broker, in most cases had that requirement anyway, but now it's officially an SEC requirement under Rule 10b5-1. Interestingly enough, what the SEC proposed a cooling off period also for the issuer. Basically, let's say the company itself wants to do a stock repurchase plan, or basically they want to purchase shares in the marketplace. So there's concerns because the company knows more than the investors in the marketplace. However, there's no cooling off period. They can adopt a repurchase plan, and there's no specific waiting period before they can implement the repurchase plan. Obviously, we know there's various stages under Israeli law for Israeli companies as far as being able to. Sometimes you have to obtain court approval to have sufficient funds for what's deemed a dividend, because the stock repurchase is a dividend. But in any case, there's no cooling off period from the perspective of Rule 10b5-1 for an issuer plan. The other point, the second point about that as far as the new amendments is director and officer certifications. It's something that applies to the 10b5-1 plan itself. You're not going to receive the benefit of a 10b5-1 affirmative defense under the SEC rules if the plan itself does not include some sort of representation from the insider that they're not aware of material non-public information. They're adopting the plan in good faith, not as a way of a scheme of evading the requirements of the rules and avoiding the prohibitions of Rule 10b5. So that's a second key element of the 10b5-1 amendments. Okay, another element that was adopted is as far as the problem of gaming the system, basically having multiple plans in effect at the same time. So currently there was prior to the amendments there were no such limitations. Now there is such a limitation. You're only permitted to have one plan in effect at a given time. And so you cannot like enter into an overlapping plan. There are certain exceptions. One exception I think is interesting is that as far as sale to cover, some of your clients I know have this question all the time. Or an ordinary level employee doesn't necessarily have the cash to they want to for example, they want to exercise options. They don't want to go out of pocket and pay the money. So what do? They sell on the same day that they exercise the options. So the question is whether those sales, is that considered like a separate plan that might, if you have also a 10b5-1 plan in effect, will that ruin your affirmative defense under 10b5-1? So the SEC generally says that it's fine. You can have a sale to cover under a different plan, like the company's equity plan, and there's no problem having that since basically the insider is not controlling the decisions under the equity plan. That's the company itself makes those decisions generally, and it's done automatically. It's based on a pre-existing schedule for the equity grant. There's certain days when it vests and when you'll you'll exercise in your cell. So there's no concern that you're choosing those days in advance. So therefore, there's no problem having that, running parallel with your 10b5-1 plan. And the other point is that you could have a second plan in effect, 10b5-1 plan in effect at the same time, so long as it doesn't actually start with transactions until there's a cooling off period, between your current plan and that additional plan. So in theory, you could have two plans, entered into at one time, but you can only have one effective one that's actually affecting transactions at the same time. You'll still need the cooling off period. So that really won't help you so much per se, but it will, for some reason you want to set up two plans at once, you could, so long as they're not, running in parallel, as long as there's a cooling off period between the transactions under the two plans. So yeah, so the next point is what I said before about a single transaction plan, which my personal experience, I found that somewhat rare, which is that, you set up a 10b5-1 plan to affect, it all goes in one shot. You have one major transaction. So if you're going to do that, there's a restriction under the rule amendments. You cannot have had such a plan that has, all the entire plan going through one transaction. You cannot have had such a plan within the last 12 months. There's a restriction on that. The additional point that the new rules raised is the point about good faith. Until now, it was basically the rule just said you need to enter into a 10b5-1 plan in good faith. Basically, that you didn't have material inside information when you adopted the plan. Now the SEC is getting at the point of you need to act with respect to the plan in good faith, which means that again, you cannot any decisions that are made by the insider who has this 10b5-1 plan. He cannot sort of like try to influence others to do anything that would call into question whether the plan is running on under good faith. So for example, if you materially modify a trade under your 10b5-1 plan based on material non-public information in order to profit more from the trade, or you're going to influence the timing of a corporate disclosure, like for example, bad news, you convince the company, the issuer, to release the news after your sale is about to happen, so you make sure that the price stays higher, or the opposite, you make sure that good news is only announced after you do a purchase under your 10b5-1 plan, so that you get you benefit from the cheap price under your plan, so that if you assert your influence in any way like that, you've violated the good faith requirement, and you're no longer entitled to the affirmative defense of 10b5-1, and basically somebody could question whether you violated the insider trading prohibition. So it's an additional aspect of the amendment. Also, any change to an existing plan is deemed like the adoption of a new plan. So the idea is, until now, you could have, for example, you could have, in theory, like you could have canceled sales under your plan. You wouldn't necessarily you would not have violated insider trading, because you're doing the absence. You're basically, it's like shev al taseh, right? You're basically, you're saying I'm not going to enter into these trades. Well, that's great. Maybe until now you would have been fine with that, but now under the new rules, what you've done is you modified the plan, and because of that, you cannot enter into additional transactions under the plan until you go through a new cooling off period. So any sort of whether it's the change in the amount, the price, the timing of the purchase or sale, anything of that, any change of that sort requires a new cooling off period. So it's not so simple anymore for an insider to just make changes under their plan and say, oh, even during a window period when you're free of non-public information, still, if you could have done that. Now you can no longer do that without having to go through another cooling off period. So you can't just make any changes. The one exception is if you're simply doing a technical substitution of the broker that's running your plan, that's okay. If it's not impacting the substance of your trades under your 10b5-1 plan, then there's no issue. You can change the broker. If you change the broker though, and you also change the plan, then it requires a new cooling off period. So that's something to keep in mind. Okay, as far as, for those of you who are issuer side participants in this webinar, whether you're inside counsel or you're responsible for the reporting of the company one way or another, CFO. So something to keep in mind are there's all sorts of new disclosure requirements related to insider 10b5-1 plans. So most of these will apply to U.S. domestic reporters, right? Which is companies that do not qualify as a foreign private issuer, whether it's an Israeli company or a U.S. company or a company incorporated in somewhere else like the Cayman Islands. So most of these do not apply, but a bunch of them do apply. So let's go through them. So first of all, on a quarterly basis now, there's new items that are being added for Form 10Q and 10K, whether with the first 3 quarters or the last quarter of the year. There's to an extent you're going to have to report 10b5-1 plans entered into by your officers and directors, or the modification, termination of any such plans. You'll need to report that on a quarterly basis. That's completely a new disclosure requirement. You will need to provide the date, the name, the title of the director or the officer, duration of the plan, and the total amount to be purchased or sold. You do not need to include the price. I guess that's something that's generally considered more sensitive and not necessary. The SEC did not require that as far as the disclosure for 10b5-1 plans. And again, this is only for officers or directors. Currently, for an issuer plan, if the company itself has a 10b5-1 plan for repurchases, for example, you do not need to. There's not like a quarterly disclosure requirement for that. There is, obviously separate requirements for issuer repurchases of shares under both Form 10K and 20F, but that's not really related to the insider trading policy. The 10b5-1 aspect of that disclosure. So these quarterly disclosures are not applicable to foreign private issuers. There's another additional annual disclosure that is applicable to foreign private issuers, like Israeli companies, and as well as to U.S. domestic issuers. And that is if for Form 20F, it's in item 16J. It also applies to Form 10K or proxy statement for U.S. domestic filer. That is, you'll need to actually disclose, do you have insider trading policies or procedures? Until now, if you ask me, do you need to file publicly your insider trading policy? The answer would be no. Now, you will need to actually file a copy of the insider trading policy as an exhibit to the Form 10K or the Form 20F. Again, like I said at the start, this will only kick in at the end of 2024, not the Form 20F coming up or 10K coming up, because just the way the SEC made the effectiveness. So, but it will be required at that point. So just something to keep in mind. To the extent a company does not have a insider trading policy, they'll need to disclose why they do not. Now, as far as Section 16 reports, again, it's officers and directors of U.S. domestic filers. So there's a new check the box item that if you file a form, basically the point of the form 4s are to report, within 2 trading days, whether insiders are selling shares or purchasing shares, what the price is. So there's a new check the box to say if you're doing so pursuant to a 10b5-1 plan. The idea behind that is to give investors more information. They want to know, so they could try to piece together between that and also between the issuers' disclosures as to what insiders are adopting 10b5-1 plans, what sales or purchases are occurring under those plans. They'll put that together with the Section 16 reports and try to understand better what prices these insiders are selling at, whether it's under 10b5-1 plan. Presumably that's something positive, because it shows they clearly did not have any inside information when they effected this purchase or sale. But it's just a check the box thing, so everybody will be able to see that in the Form 4s that are filed. Also Form 5, which is a little more rare. Okay, again, there's another point for U.S. filers in the Form 10K annual report or proxy statement. There needs to be there's disclosures that will be required regarding option grants and the timing of option grants. Again, this is trying to get at the point of whether when there are option grants that are made either immediately before the release of good information, which means that you're going to set the exercise price at a lower price, and suddenly the price of the stock is going to go up because you're going to release the material information, good news. So that's called a spring-loaded option. So you need to that's going to need to be disclosed. This the SEC is doing in the context of executive compensation disclosure. So they want to know which companies are giving these benefits to their insiders. Giving them either cheap option with cheap exercise price, or on the other hand, what's called bullet dodging option grants. Basically, if you wait for an option, if there's bad news, right, and you want to avoid the stock, you want to give people a chance to avoid the bad news, to be able to sell at a higher price. So you'll time it before the bad news, give people a chance to maybe to vest or to sell at a higher price. So that's also something that the new rules are going to target again for U.S. domestic issuers. So the other point here is that there's going to be various disclosure in executive compensation as far as policies and procedures, timing of awards. So this gets into the point I'll cover at the end, which is it's good to have an equity grant policy. That basically equity should be granted after the release of material non-public information, so that the market has digested that information, and so that equity is being evaluated, whether it's RSUs, options, the price that's being used is a price that reflects all material information in the marketplace, and that the issuer is not holding back any information. So that's one of the takeaways from the SEC's new rule changes, is to try to establish an equity grant policy to the extent you do not have one. Even though that this is a U.S. issuer disclosure, doesn't apply to a foreign private issuer, but it's still it's best practices that we would recommend to all of our clients. Again, there's a new table within this executive compensation disclosure that's going to describe any options are granted within 4 business days prior to, or within 1 business day following the release of material non-public information, whether that's the filing of a 10Q, a 10K, or an 8K for certain events that under 8K. Some events under 8K are accepted out because it's not necessarily considered the most material information, but there's going to need to be disclosure if you're granting equity close to either prior to the release of information or within 1 day after the release of information, when the information is assumed at that point not to have been digested by the market. We don't want people, companies doing that. So basically, the SEC is exposing them by providing that they need to disclose this in their executive compensation tables. That's a new table that will be required for U.S. filers in their proxy statements or in the 10K. Again, it needs to, that table needs to include various information, such as, for named executive officers. Those are the officers for whom executive compensation disclosure is required. You need to name the date of the grant, the fair value, various, as far as the valuation method used in the financial statements, and the exercise price, and then to also disclose the percentage change in the closing market price of the shares underlying the award. That really gets at the point that basically the insider is getting away with a either very cheap option grant or they're somehow able to avoid bad news. So the impacts of bad news. So it's also granted before the bad news is released, so they can basically game that system as well. So this is again is executive compensation type disclosure. It's required for only not for foreign private issuers. But I think one of the takeaways from this is important. If we get to some practical takeaways, so basically companies should reconsider their policies regarding senior officers. I haven't seen this really with most of our clients as far as requiring like senior officers only to trade within a 10b5-1 plan. It could be there are certain companies that have that. If that's the case, because of these new requirements related to 10b5-1 plans, it might be that 10b5-1 plans are more disadvantageous at this point because there's a cooling off period, because there's various good faith requirements, and there's a lot more scrutiny from the SEC's perspective. It might make more sense for if a company has a requirement that its officers and directors need to only make trades under a 10b5-1 plan, that maybe makes sense to open up the possibility of not requiring 10b5-1 plan trades, and instead allowing the officer or director simply to do a sale or purchase, for that matter, with a certain amount of time close to the last earnings release. That's the ideal time when the insider trading window opens. All material information is considered to be in the marketplace. That might be a better option than using a 10b5-1 plan because of all the scrutiny. So that could be one takeaway for an issuer, for a company that that has such a requirement in place. Another obviously takeaway, which applies both to insiders as they're reviewing, presumably in most cases, insiders, my experience is that they have 10b5, you enter into a 10b5-1 plan with a broker, with an investment banker, and the investment banker typically has a form of 10b5-1 plan, that the insider enters into with the banker or the broker. So they obviously need to review their forms for compliance with the new rules. I've seen already, like some of our clients, the 10b5-1 plans that their brokers have crafted already are modified, but it's worth it, obviously, for the insider, for their counsel, for the company as well, to the extent they're involved in the process with the insider, to review those forms and to ensure that they reflect the new requirements as far as not prohibiting subsequent modifications to the plan, as far as requiring the representation from the insider as to good faith, and as to that they're not getting around the prohibitions of the securities laws. So you need to be certain that the form of 10b5-1 plan that you're entering into has those representations from the insider, and it's worth to just check those plans, those forms for compliance with the new rules. Whether, again, like I said, whether you're the insider or even the issuer, to the extent that you review. In many cases, I've seen that issuers have the right to review the 10b5-1 plans that their insiders enter into in advance. So the issuer also should review to make sure that's in compliance with the new rules. As to insider trading policies themselves, my view is that the new rules if it's a U.S. domestic issuer, then there would definitely be some modifications required, as far as because of the interaction, because of the requirements for enhanced disclosure on a quarterly basis of which insiders are entering into transactions, and when what and the details. So it's important that your insider trading policy has a way, like, practically, for that information to be conveyed to management, or for the person actually who's the legal officers who are in charge of basically monitoring the 10b5, the insider trading policy, excuse me. So you would want to make sure that all those mechanisms are in place. Even for foreign private issuer, I would say that although there's no absolute requirement to necessarily to change your insider trading policy, since most of the disclosures are not relevant to foreign private issuers. I think it's obviously still worth it for to review the insider trading policy in light of these amendments adopted by the SEC, to better whether to understand what the provisions are with respect to Rule 10b5-1 plans, as far as when they become effective, and how that works, how that interacts with the insider, with the company's own restrictions on insider trading. So definitely it's worth a review of the insider trading policy. Again, and the next takeaway I would say is adoption of equity grant policies. I touched on this before. specifically because the SEC is as far as executive compensation disclosure is requiring, disclosure as to the timing of option grants, whether it's right before the release of material information or right, immediately after, before the market digests that information. So it's worth, if you have not adopted an equity grant policy until now, it's probably worth exploring to adopt one that's really, I would say that's best practice for a lot of our clients to begin with. As you want to have, you want to have clean hands to the marketplace. You want people to realize that the company has is granting equity in a fair way after all material information is released to the marketplace. Right when the insider trading window opens, that's the time to do equity grants. Not before you might have to disclose something that's material inside information. So it's worth it to set up an equity grant policy of that sort. Another, I think a general takeaway is the implementation of rule requirements, internally at the company, and having enhanced disclosure controls and procedures. Obviously, this is, a lot of this information relates, these amendments to 10b5-1 relate to the insiders themselves. Some of it relates to the issuers, but obviously the issuers don't want their insiders violating these requirements, right? You don't want your insiders. It's bad. It reflects badly on the company itself. It reflects, it does not necessarily bring liability to the issuer, but there are issuer disclosures that are involved now, and especially if you're not a foreign private issuer, so you want to basically educate your insiders as to what the new rule requirements are, and you want them to be aware of the new requirements as far as how it impacts Section 16 filings, as far as checking that box in the Form 4s or Form 5s. You want them to be communicating that the information regarding their trades to the company, so that you, on a quarterly basis, if you're not a foreign private issuer, you can report that accurately. So you need enhanced disclosure controls and procedures. You need means of coordinating action together with your insiders. You want to be able to, you don't want to be caught without that information. I'd say that's most of the takeaways, I would say, on a practical level. I think that it's clear that this is a policy-based these are policy-based amendments. Whether we all agree with them that they making life harder for insiders is a good thing or not. There definitely were abuses in the past, and this is sort of closing the gap, and that's part of for better or for worse, that's part of what the current SEC regime under the Biden administration has been focusing more on actually on regulation rather than necessarily the flip side of the coin, which is more capital raising. But in any event, it's worth it for anybody on this webinar to be aware of these changes. Personally, I'm happy to be in touch with each and any of you individually. Happy to answer any questions. I don't see any current questions, but hopefully I'll get in touch with you following this webinar. We can discuss any, feel free to send to one ask in obviously be Hebrew or English, either one works. And I think that these rules are already in effect, start already as of February 27th. So it's important to the extent that anything companies or insiders are not currently aware of them, aware of these changes, to make them aware of them, and happy to share materials with you and answer individual questions or otherwise going forward. So unless anybody has anything, I think the way they set this up is without having verbal audio questions. So I think we will probably just bring this to a close. It's been a pleasure trying to convey this information to you, and hopefully you be able to use it productively in planning further steps, whether internally at the company or as an insider, hopefully have better knowledge as to what's going on in the under the SEC rules. So I appreciate very much you're taking the time out to שמחתי מאוד שהצטרפתם, ואם יש לכם איזשהו follow-up, אני מאוד שמח לעזור לכם תמיד. Okay, I think I'm gonna bring this to a close. This will be available to the extent there are others at your company. I think we'll have a recording of this, so I'll be happy to share the webinar with you later on. תודה רבה, and המשך יום טוב.